Hi there, I'm Godwin Salasidapo, and this is Make It Legal. On March 8, 2011, the High Court of Ghana delivered a judgment in a case that was brought before it on June 25th, 2007. The High Court simply says a judgment that was obtained from the Court of Appeal in 1982 should be set aside on grounds of fraud. And the party against who the judgment was rendered was unhappy with the decision of the High Court. So the party appealed it to the Court of Appeal. And the Court of Appeal delivered a judgment in 2015. And the party against who the judgment was rendered by the Court of Appeal, of course, the Court of Appeal disagreed with the High Court. That party who sent the case to the Court of Appeal, the lawyer calls that party the appellant, was not okay with the decision of the Court of Appeal. So that party also appealed the decision to the Supreme Court. And on the 22nd of March 2023, the Supreme Court delivered the judgment settling all matters in dispute. In this video, I present to you a review of the facts, the issues, and the court decision. Make it legal. In just a few minutes, I'll be presenting you the facts of the case, the issues that were before the court, and then the decision of the court itself. So let's start straight away with the fact of the case. What were the facts in dispute between the parties? Remember, this was a case between 40 plaintiffs as against 3 defendants. Defendants are the one who the case is brought against, and the plaintiffs are the ones who bring the case against the defendant. So at the Court of Appeal, the 14 persons were the appellant, and the 3 persons were the respondent. So the case was at the Supreme Court by the 14 appellants who wanted the court to do certain things. But first, let's get the fact clear. Now, these are the brief facts. The National Liberation Council, which was the government in power at the time, decided to compulsorily acquire some parcels of land to establish a TV station for the Republic. And they needed about 25.03 acres of land to establish GBC, Ghana Broadcasting Corporation. And these lands were already lands belonging to individuals and families. And when the government acquires it compulsorily, always would have to compensate the owners for taking the land from them. So on the subject of making claims for compensation, 3 families applied for compensation to be made to them. So 3 families were claiming to be the owners of the 25.03 acres of land that the government had compulsorily acquired for the TV station. The Numo Nmashie Family of Teshi were also one of the parties. So the state set up a tribunal called the State Lands Tribunal that was headed by Justice Aban. This tribunal was to take the applications from persons who claim to be the ones who are entitled to compensation and review it and see who is actually the right person who deserves compensation or who is the right owner to be given compensation. So at the end of the work of the tribunal found as a fact that the then Nana Edu Miraku Ajima III, who was the then chief of Berikusu, were the ones entitled to compensation, not the Numo Nmashie family. Now, the Numo Nmashie family were aggrieved by the decision of the tribunal that no, we are the owners of the land and we are the ones who are supposed to be given compensation. So they appealed the decision of the tribunal to a higher court, which is the Court of Appeal at the time, in the year 1980. And as of 1982, the Court of Appeal, presided by 3 prominent judges, gave their decision. Before they arrived at a decision, they had requested that a site plan, which lawyers will call composite plan, be prepared to show all the boundaries of the land, all the dimensions of the land, and then all the various portions in dispute or not are well ascertained. So the court appointed a surveyor, which we call a court-appointed surveyor. So that surveyor, his job was to go onto the land and be assisted by the parties to ensure that the site plan of the land that is in dispute is generated for the court study and to help the court in delivering judgment. So when this site plan was finally concluded and brought, it was clear that the site plan has actually included about 70 villages. They were called villages at the time. Some of them are now cities, but 70 villages, and actually extended to over 72,000 acres of land instead of 25.031 acres. That was actually the land that was acquired compulsorily. The court was not really bothered about ascertaining the size of the land at the time. So he went ahead to declare that from the evidence, the Numo Nmashie family members or persons they granted the land to were the ones in possession. And in law, when you are fighting over a title and one party is in possession, the one who is in possession, who is actually on the land, has a better position than the one who is not on the land but is trying to say that he is the owner. As a matter of fact, the Nmashie family were already occupying some portions of the land. So they were the owners of the land. So the court declared that they were the ones entitled to compensation for the compulsory acquisition of 25.03 acres of land. By reason of the Court of Appeal judgment at the time that they were entitled to compensation, went ahead and accepted ownership right over the 70 villages that were mentioned and over the land that was covering approximately 72,000 acres. They were now claiming to be the owners because the court said that you were entitled to take compensation. So if I could take compensation, it means that I was the owner. So let me show my ownership interest and accept that right I have as the owner. The 70 villages we are talking about here, I can't mention all these 70 villages, but some of the common ones, I can mention them. And then you want to check and see if your village or your city is one of them. What are these villages? So we have Peduase, we have Brekusu, we have Upegono, we have Madina, we have Fafraha, we have Pantan, Ashoman, Ashalebuche, Ablekuma, Agbeleshia, Peshi, Peshi Ridge, Abokobi, La, Baoleshi. So when the Court of Appeal declared that the Nmashie family was the one who was entitled to compensation, implying that they were the ones who owned the land, they went ahead to assert their ownership right over the 72,000 plus acres of land. Quite interesting, isn't it? Now, this assertion of right was opposed by many people, and there were a lot of lawsuits that were brought against them. And many of them were actually dismissed because they respected the Court of Appeal decision that says that the Nmashie family were the rightful owners of the property or were the parties entitled to compensation. In all of these cases that were brought against them, which was dismissed by the court, none of the courts actually stated that or granted them power to go and recover possession of the land. However, on the 5th of March 2007, they obtained an order from one of the high courts anyway, and the order was for them to go and recover possession of the land and also demolish the properties on it. But the persons who were in occupation could agree to atone tenancy to them. That means that they could say that, oh yes, we know you are now our new landlord. We are willing to accept you as our new landlord. Don't demolish our property. They granted them permission to go ahead, either take the land and all there is on it, or allow the people to keep the property and respect them as their new landlord. So there was another event as well. The Lands Commission, with all these judgments declaring that they were the owners of the land, the Lands Commission has to do its job. So it was going to register the lands, all these 70 villages, in the name of Nmashie family to declare that indeed they are the owners of the land. So the Lands Commission was going to do that. But the plaintiff in this case filed a suit at the High Court to say that no, the Lands Commission cannot go ahead to do that because we have evidence that shows that the Numo Nmashie family are not the owners of the land that covers over 72,000 acres. They were not the owners. They filed a suit at the High Court, seeking, among other things, the relief that the judgment that was granted by the Court of Appeal was based on fraud. What was the fraud? The fraud was that the composite plan that was prepared was supposed to cover 25.03 acres of land and not 72,000 plus acres of land. So obviously somebody lied to the court about the land size that was compulsorily acquired by the state. So what was the plaintiff case at the High Court? In fact, they made a very simple case. They stated that we are the owners of this land. Some of the villages that the defendant have accepted or have claimed to be their own are not part of their lands. The compensation claim was only in respect of 25.03 acres. And they are not the ones who own the 70 villages they claim. Therefore, the court should declare that the judgment that granted them 70 villages was obtained on grounds of fraud. Therefore, should be void. Now, because there were three defendants, the first and second defendant also made a case. They filed their defense and said, you know what? All that the plaintiff is saying is not true. We are the owners of the land, and our ownership was declared by the Court of Appeal judgment in 1982. Therefore, the High Court should respect that judgment and declare that yes, we are the one. and prevent the plaintiff from continuing with the litigation. The third defendant, which is the Numo Nmashie family in this case, they also filed the defense saying, you know what, my lord, this case has been concluded by the Court of Appeal and we respect the Court of Appeal decision. Let all parties respect it. So let's not allow the plaintiff to reopen litigation and to relitigate the matter already decided by the court. So that was the defense. And you know what? This was decided by the court, and the court ruled that we are the ones who were entitled to compensation, implying that we were the owners. So you cannot now be seeking to have a new fresh action to declare you as the owner. It will amount to reopening the litigation altogether. So the High Court, upon hearing this case from the parties, ruled in favor of the plaintiff because the High Court reviewed all the evidence and found out for a fact that the Court of Appeal actually relied on the composite plan that was prepared by the court-appointed surveyor. And that composite plan actually covered the land size that was more than 72,000 acres of land. Meanwhile, the land that was in contention for which they were claiming compensation was 25.03 acres of land. But the High Court also emphasized that the arguments of the defendant that the plaintiff was reopening litigation over a matter that was handled by a Court of Appeal already was not tenable, because when it comes to issues of fraud, you cannot hide behind res judicata to avoid the implication of fraud. Once fraud is discovered, it scatters everything. It makes everything void. You cannot hide behind res judicata, that doctrine of law, that the court should not hear the plaintiff again because the matter has been decided already by the Court of Appeal. The court said that doctrine, res judicata, which means don't re-decide a matter that has already been decided by a court, or don't re-hear or re-litigate a matter already pronounced or an issue already pronounced by the court. But the High Court said that no, I understand what you are saying, but as far as the issue of fraud or allegations of fraud is concerned, res judicata does not apply. With this analysis, the High Court concluded that the 70 villages in question do not belong to the Numo Nmashie family. All the defendants at the High Court disagreed with the High Court ruling. They were so dissatisfied that they all appealed against the decision of the Court of Appeal. And the Court of Appeal also reviewed all that the High Court has done and came to the conclusion that no, the High Court was wrong. That is interesting, right? The High Court gave a decision agreeing with the plaintiff. The plaintiff was declared the winner, but the plaintiff accepted it and said, well, I'm the winner. That's exciting news for me. But the defendant in the case said that no, we don't agree with the court. So they appealed the decision of the High Court to the Court of Appeal. The Court of Appeal, upon reviewing the judgment that was delivered by the High Court, said that, you know what, the High Court, you were wrong. It was a burden on the plaintiff to produce sufficient evidence to show that there was fraud committed, or there was fraud based on which the judgment of the Court of Appeal at the time, that is the 1982 judgment, was obtained. And from our evaluation of the record and the evidence they brought, none of the evidence actually show fraud or deceit on the part of the defendant. Therefore, we are going to overturn your judgment and put our own judgment in its place. And our judgment is that the Numo Nmashie family remains the owner of the land, as was upheld by the Court of Appeal in 1982. So this was a decision of the Court of Appeal. Should the plaintiff also accept that decision as right, or should challenge it? What do you think? Let me hear you in the comment section. I'm sure you got your answer right. The plaintiffs were not in agreement with the Court of Appeal ruling. They disagree with the Court of Appeal. So the Court of Appeal, you were wrong. So what could they do? They would have to challenge it in another court. You don't go to the streets and start demolishing property, start making noise because you disagree with the court. No, you go see a lawyer and file an appeal against that decision. So they did just that. They filed an appeal at the Supreme Court to challenge the decision of the Court of Appeal that overturned the High Court's decision. So at the Supreme Court, they simply asked the court to grant them a number of reliefs. The first one was that the court should declare that the judgment reached by the Court of Appeal cannot be supported by the evidence on record. That is what they want the court to declare. They also want the court to declare that the Court of Appeal was in error when it came to a conclusion that there was no fraud, or fraud was not perpetrated in obtaining the judgment of the Court of Appeal in 1982. They also sought from the Supreme Court an order that the Court of Appeal failed to appreciate that the doctrine of res judicata, as we call it, that is, don't really litigate the matter already decided by a court. That doctrine was an exception to the concept of fraud or allegations of fraud in a case. They said the Court of Appeal failed to appreciate it. Therefore, Supreme Court, relook at the whole case again and see whether or not the Court of Appeal is still right, or we are right, or the High Court was right. So you should make the High Court decision, which was initially in our favor. What was the judgment of the Supreme Court? So the Supreme Court delivered a judgment, and in the judgment, they actually started by clarifying two key concepts of law. At what stage of trial proceedings would the court ignore all these two principles allegations to come to an end, and that when the court has decided the matter already, it should not be reopened by a party? One of the instances is what was happening in this case. That was the case of fraud. When a party alleges that a judgment that was obtained by fraud should not stand, that party must be heard. So the court emphasized that as far as the issue of fraud is concerned, once it is discovered by any court, the court must go ahead to declare whatever is based on that fraudulent act void. In line with that thinking, the court clarifies that as long as you discover that there is fraud which influenced the decision that was made by the court, you are an obligation to file a fresh action in the court to have the judgment set aside, because fraud, which is deceit and dishonesty, vitiates everything, cancels everything, and makes everything crumbles. It demolishes the strongest of all foundations. So the Supreme Court also has to answer a second question, which was there enough evidence before the High Court and even before the Court of Appeal that proved the fact that the defendant, that is the Numo Nmashie family and the two other defendants, actually perpetrated fraud on the court that gave judgment in their favor in 1982? Was there evidence on the record enough to lead to that conclusion? In answering this question, Supreme Court found out that the matter before the Court of Appeal in 1982 was actually a case that focused on compensation and not ownership of the land. And it was also a case that focused on 25.03 acres of land and not 72,000 acres of land or 70 villages. So where at all did the 70 villages come into the picture before the court went ahead to declare that they were the owners of 70 villages? So the Supreme Court found out that no, the Court of Appeal at the time had no business to decide on the ownership of the land or on the ownership of 70 villages that were the subject of this judgment. So they obviously erred. And again, it was clear to the court that some of the witnesses actually admitted that some of the villages that were part of the 70 villages were not part of the lands that belonged to the Numo Nmashie family or any of the defendants. So what it means is that somebody actually lied to the Court of Appeal in 1982. And based on that lie, that dishonesty, the Court of Appeal acted or gave its judgment. And once there is deceit and dishonesty at that degree, that from all indication it was so clear that there was deceit and the court was lied to, the composite plan gave a larger size of land, 72,000 plus acres of land, instead of 25.03 acres of land. It is a lie, and the court has to take an action to declare whatever is based on that lie to be void and of no effect whatsoever. So on the basis of that discovery by the Supreme Court went ahead to say that, you know what, the High Court that gave the decision in favor of the plaintiff was right. The High Court was right in finding that there was fraud perpetrated on the Court of Appeal in 1982. The High Court was right in finding that the judgment that was obtained by the Numo Nmashie family and the other defendant in 1982, that made them the owners of 70 villages, was actually obtained by fraud. And upon that discovery, they went ahead to say that the judgment should be set aside. The judgment they obtained, which is the basis of their ownership as they have been accepting for over 40 years, should be set aside, should be declared void and of no effect whatsoever. However, the court gave some few cautions. You know, when you have a landlord and the court is now declaring that that landlord, who has been your landlord and owner of a land for 40 years or more, is no longer the owner, it could create chaos in society. It could make people get panic. So we are talking about 70 villages, including places like Adenta, places like Medina, places like Agboba. These are all very great cities now. They're no longer villages anyway. And if they declare that the person who was the owner is no longer the owner, is a new owner, it could create some chaos. So the court has to regulate it by some additional orders. So the court made what we call consequential orders. So these orders are intended to regulate how the court judgment declaring that Numo Nmashie family and the two defendants are no longer the owners of the land is well implemented. The first one was that the judgment should be treated as declaratory and pronouncement, and nobody should treat it as a judgment authorizing recovery of possession or demolition of any property. So, in other words, if you have a property acquired from the previous owners of land, that is the Numo Nmashie family, and the Boi Stool and the rest cannot come to demolish your property. However, since the Numo Nmashie family and the other defendant are no longer the owners of the property, they would approach you to accept that that is the plaintiff in this case, will now be your new landlord for those villages that are concerned. So all the lands that fall within this town that belongs to a particular stool or a particular individual, that stool or that individual will be the landlord that you would atone tenancy to. And it simply means that you and that landlord have to sit down and agree on the new terms of your continuous stay on the land. He may say that, you know what, I am now the owner, and I think this my 2 plot of land will be selling for $10,000 and not $2,000 as you bought it in whatever year. Therefore, bring additional this amount of money before you continue to be the owner. If you don't agree to this term, I take my property back, and then you leave it because the one you got it from was not the owner, you got it by fraud. So this has been the review of the case of Boi Stool and 13 others versus Numo Nmashie Family and 2 others. I'm Gordon Selassie Dakbo, and this is Make It Legal. Make it legal.